As a part of the law revision series, the second important class is types of contracts. CA Foundation Law students who are appearing for September exam, make sure you don't miss any of these revision videos. It will definitely help you to revise last minute and have a clarity and answer case law questions. The next important topic is types of contracts. So the first important thing is valid contract. Valid contract is a contract that is enforceable by both the parties. In other words, it is a contract which satisfies all the essential elements that are given in section 10. I repeat, valid contract is a contract that is enforceable by both the parties and it satisfies all the essential elements of valid contract that are given in section 10. Alright, the next very important thing which most of the students generally confuse is void contract. So what is this void contract? A contract which was valid in the beginning and because of unexpected events that have taken place, it ceases to be enforceable by law. I repeat, the contract which was valid in the beginning, later on due to some unexpected events such as death, change of law, destruction of the subject matter, because of any of such reasons, contract has become void. That means it was valid in the beginning, because of unexpected event it has become void. That is void contract, ceases to be enforceable by law. Alright, next contract, voidable contract. Since it's a recorded class, you just go back and rehear once again. It will definitely help you to have some clarity. Don't worry about it, right? The next important thing is voidable contract. When two parties entered into contract, if one party consent is taken by force, is taken by fraud, is taken by misrepresentation, is taken by mistake, or is taken by undue influence. I repeat, when one party consent is taken either by coercion or by fraud or by misrepresentation or by mistake or by undue influence, then the contract becomes voidable, which means only one party who is affected can enforce the contract. So voidable contract is the contract which is enforceable but only by the affected party. That affected party is because of coercion, misrepresentation or mistake or undue influence, fraud, etc., etc. Alright, next one, illegal contract. The contract whose objective or consideration, is unlawful. Objective is basically the purpose of the contract, consideration is basically something in return. So when the contract objective or consideration is unlawful when, so it becomes unlawful due to fraudulent objective, due to immoral objective, due to objective which is opposed to public policy. So due to objective which is fraudulent, which is forbidden, which is immoral, which is opposed to public policy, or if you allow such objective, it would defeat the legal provisions. If in case any contract that satisfies the objective or consideration fraudulent, forbidden by law, immoral, opposed to public policy, or it would defeat the law provisions, or it causes injury, the objective between two people causes injury to the other person, then it becomes unlawful object or consideration. When the objective is unlawful or consideration is unlawful, 100% the contract is going to become illegal. Alright, next very important contract is express contract. When both the parties have entered into contract either by the words spoken or by the words written. I repeat, when both the parties have entered into contract either by the words spoken or words written, it is called express contract. That means both the parties will speak to each other, oral agreement, or both the parties will write a letter to each other. That is express contract, either in written form or oral form. Alright, next one, implied contract. Implied contract is the contract where the rights and obligations of the parties are created by the conduct or behavior of the persons. That means they do not speak anything, they do not talk anything, they do not write anything. It all depends on behavior of the parties. Say for example, the moment you touched ATM and withdraw the cash, you have entered into contract with bank. Understood? So the moment you got into a bus, your behavior of getting into bus indicates that you have entered into contract with bus. So implied contract, you will not have oral words spoken or written words written. Alright, next very important thing is quasi contract. The word quasi means similar to or resemblance. So when I say quasi contract, it is similar to contract but not a contract but valid contract. What does it mean? It does not contain offer and acceptance. It does not contain offer and acceptance, but the rights, obligations are created by law. So when usually rights and obligations are created by parties. If in case rights and obligations are imposed instead by law, that becomes quasi-contract, and it is also enforceable just like a normal contract. Only thing is, it's not a real contract, it is based on law imposing obligations. Alright, next one, executed contract. Executed contract is a contract where both the parties have performed their obligations. That means if A has an obligation, B has an obligation, both the parties have done their respective obligation and nothing is pending from both the sides. That is called executed contract. Means A agreed to supply goods, he supplied the goods, B agreed to pay the cash, he paid the cash, which means both the parties have performed their respective obligations. Then we call it as executed contract. Got it? The next contract, executory contract, where both the parties are waiting to perform the contract. When both the parties have completed what they are supposed to complete is called executed. When both the parties are waiting to perform, suppose tomorrow is the due date to perform the contract. Say for example, A has agreed to supply the goods and A would supply the goods tomorrow. So this is executory today. So executory contract is the contract where the obligations are yet to be performed by both the parties. Yes. The next one, unilateral contract. Unilateral contract is a contract where one party has to perform. Unilateral means one party has to perform. That means other party might have performed, must have performed, or need not perform. So say for example, if you paid an advance fee and you already have done what you're supposed to do, the other party has to do. That is basically unilateral contract. So in unilateral contract, you will find partly executed where one party has done, partly executory where one party is waiting to do. It all depends on the situation. Next one, bilateral contract. The contract where obligations are outstanding on both the parties. Remember one thing, whenever there is a contract entered, both the parties have respective obligations created by them. That means when you have obligations outstanding on both of you, it is called bilateral. So by default, every contract is bilateral. So such bilateral contract is nothing but where the obligations are outstanding on both the parties. If they have finished, it is called executed contract. If they are waiting to finish, that is called executory contract. Have a clarity on the types of contract. Trust me, this will help you, and make sure you subscribe the channel. We are from Brics Academy. I'm the director of Brics Academy. We are based at Bangalore, and make sure you watch my classes, revision tips and classes. This will help you last minute revision. All the very best. Thank you so much.